Goeiemôre dames en here en welkom by die 6de sessie van NAMPO, Agnasie in gesprek by NAMPO 2025. Vandag se tema van die gesprek is die onteieningswet. So dit is iets wat ons maar almal ongemaklik maak en onseker. En dit is 'n gesprek wat ons moet hê en dit is 'n belangrike gesprek, sodat ons almal die impak van hierdie onteieningswet kan verstaan. En dan daar volgens net die positiewe kant ook sien. Want as mens na die onteieningswet kyk, is die eerste ding wat jy aandink is negatief. En ek dink dit is altyd net negatief, maar ons moet verstaan wat die impak daarvan is. Waldemar en die paneel, baie dankie dat julle bereid is om die moeilike gesprekke te voer. So ons gaan net 'n kort inleidende video kyk en dan gaan ek oorgie aan die paneel. Sterkte vir julle.
In South Africa, land is more than heritage. It's a platform for growth, a foundation for dignity, for food, for infrastructure, for inclusive development. The Expropriation Bill is a legal framework that enables government to acquire property for public purposes in a manner that is fair, transparent, and lawful. It applies across sectors, not just in land reform, but also to facilitate infrastructure, housing, and service delivery. Expropriation can only occur under defined circumstances, and only after all efforts to reach agreement have been exhausted. It's not the first step, it's the last resort. For commercial agriculture, the bill raises important considerations: investment certainty, security of tenure, and long-term operational planning. How will the bill influence land valuation, lending, expansion? With inadequate communication from government, many fears and concerns remain around the implementation of this bill.
It is unfortunate that a bill like this creates more uncertainty and creates further divisions instead of fostering inclusive growth, which I think we all know is the best way of generating economic growth for all and the better South Africa for all involved. If you look at other countries, neighbouring countries, what has happened there before, I think that does create uncertainty in the minds of many. And I think although you might want to ignore it and say you focus on the future, you focus on a growing South Africa and you do your bit to grow the economy and your own business, I think you will be naive if you completely ignore it. And I think that's a bit where all this conflict in opinions do come in and arise from, is that although it's maybe good intentions today, it is about what that outcome can be 10, 20, 30 years from now. I think the obvious outcome of uncertainty in any business is that strategically you make decisions based on the information at hand. And for growth and future investment, uncertainty obviously is a negative. I'm fairly certain and sure that certain boards and individuals will disinvest. They'll look to the future and say, maybe I need to get out of this sector. They'll look at opportunities and they might not want to put more capital behind that. And then the obvious result flowing from that is lack of economic growth and then the obvious notion of no further job creation or less. And that's one of the key South African concerns we have throughout the country.
The bill also outlines conditions under which property may be expropriated with nil compensation, such as abandoned land or state-owned property not in use. These cases are limited, subject to judicial oversight and not a blanket policy. With so many unknown factors and case law as yet untested, agricultural role players are seeking clarity and assurances that their businesses and investments will be protected.
Now, the real risk that we see in those provisions is how it might be interpreted and applied, in the sense that it might well be that expropriating authorities offer you nil rand compensation because the Act says it's possible. And then it leaves it up to the owner to basically fight all the way to the courts. And I do believe that once you reach the courts, again, unless it's incredibly unlikely circumstances, the courts will offer proper compensation, just and equitable compensation. But it's a long, tedious, dramatic process to go, to have to go all the way to the courts. And of course, taking government to court is not inexpensive. It's not easy, so that's the real risk that we see. The risk of it affecting property values because property has been taken at nil compensation is incredibly unlikely. But the risk of protracted long litigation if the state gives offers of nil compensation. That's the biggest risk we see.
As South Africa balances the need for development with the rights of landowners, ongoing dialogue will be key. Clarity, transparency, and shared understanding must guide the way forward. Used responsibly, expropriation can support inclusive growth, connecting farms, powering development, and unlocking opportunity. Can agriculture play a role to become part of the solution? Welcome to the conversation. Let's unpack the facts and the future together.
My name is Waldemar Pelser. It gives me great pleasure to welcome our panel this morning. Debbie, also thank you very much for that welcome earlier. First up, Dean McPherson, Minister of Public Works. Still Minister of Public Works. I don't know whether your suitcase is packed. Dean, welcome. Lovely to have you here. Willem de Chavannes Vrucht. Willem assured me that his surname is not to be pronounced in a French accent. Deputy President of Agri-SA and also a commercial producer. Willem, baie welkom. Jaco Kleinhans, hier aan my linkerkant, hoof van internasionale en nou ook plaaslike skakeling vir die solidariteitsbeweging. Jaco, lekker om jou te hê. En Theo Boshoff, CEO van Agbiz. Theo, lovely to have you here. The final seat is not for Julius Malema, it is for Herman Pretorius, Head of Strategic Communications at the IRR. We think he's still stuck in traffic, but he'll join us soon. We'll try to provide as much clarity as exists about the bill, which is now an act, the Expropriation Act. And there'll be some time for questions at the end of the session. But we hope that in this conversation, which will firstly focus on the factual part of this, what is actually in the Act, what does it allow for, and then we'll move into the domain of opinion. Who is worried about what? Or, as some commentators say, is there nothing to see here? There's nothing to really be concerned about. I think there'll be some robust conversation about that last point on the stage. Dean, I want to start with you as the only representative here of national government. How do you understand the problem that government is trying to solve with this act, which replaces the 1975 Expropriation Act? What problem does government hope it will solve?
I think, Valdemar, and firstly, good morning to everyone to the panel. I think we need to be clear up front what the Act is and what the Act is not, because everyone's got their opinions, but opinions cannot trump factual law about what the truth is. So what it does is it seeks to standardize the procedure in which expropriations occur. So to say that there is a logical start and conclusion to how that process must take place. And this, in fact, is a dramatic improvement on the Expropriation Act of 1975, which did not have that sort of definition, clarity, and procedural layout. It also provides more safeguards and clarity than 1975, but interestingly enough in our research, more than US federal law does, because a lot of people keep trying to sort of show that or pretend that the concept of expropriation exists only in South Africa. It is an internationally standard practice by government to acquire land for things like economic development. And I think that your intro was incredibly helpful because, you know, often the question is asked, how do we build roads, ports, railways? And the best example that I give, Valdemar, is the 14,500 kilometers of transmission network that needs to be built across this country. Now, I'm sure everyone would agree that they would love to see the back of load shedding. And, you know, one of those is going to be to ensure that independent power is moved around the country. We can't do that without transmission lines. So you're going to have to acquire servitudes to do so. So you need an act that can also define that. And so I think that what the act does, and let me be upfront, I also have some procedural concerns, but those can be dealt with. But what I do worry about is that the answer to the question in many people's view, is just, to throw it out and to start from nil. So to answer the question, we've got to make sure that an act exists to be able to drive economic growth in infrastructure, as well as to be able to deal with things like public interest and public good, which I'm sure we'll get into later.
Yes, because this Act introduces aspects that were absent also from the 1975
Correct.
Act, including the fact that public interest can be a cause for expropriation. It also introduces for the first time explicitly into South African law the notion of expropriation without compensation.
No, that's not correct.
With nil compensation.
Nil compensation. And you see, that is an important point that you said, because people confuse an unlawful act of expropriation without compensation as expropriation with nil compensation. Nil compensation is clearly defined, and they're not the same thing.
Okay, and we'll get to whether the courts indeed play a necessary role in any of these processes before a piece of land is indeed expropriated. Theo, ek wil na jou toe kom. What are the key differences from where you are standing between the 1975 Act and this Expropriation Act, especially in conversations that you have with your constituency? What are the pain points?
Yeah, no, thank you very much. And I think the focus obviously being on this act in the 1975 Act, that's an element of it, but both of them sought to play the same role, being a procedural legislation at its heart. The authority to expropriate, and I think that's a very important point to make, that vests in Section 25 of the Constitution. And it's also contained in multiple pieces of legislation that's already in the statute book. And the 1975 Act was no different. So the basic premise of departure, to say that and I think maybe it's a flawed, or in my opinion at least a flawed perception to say if we didn't have this bill, the state couldn't expropriate. I don't think that's correct. They certainly could, but then you'd have a very convoluted and insufficient process by which to do it. So the 1975 Act, I think, as the Honourable Minister mentioned, we didn't have the right to administrative justice when it was enacted. So some certain key challenges, and I think if the 1975 Act would be used to expropriate, there would probably be a lot of legal challenges in terms of the process. For instance, it only recognized the rights of owners and the rights of registered holders. But there are multiple parties that have got legally recognized interests in law, farm dwellers, for instance, short-term tenants who wouldn't be consulted and wouldn't be entitled to compensation under the previous legislation. So from that procedural aspect, I think it was necessary to have an update. And one point perhaps I should also just add on to mention is we're talking about the procedural mechanism here, but I've heard the concept of a policy of expropriation, to say that now that we have got a legislation, is a state embarking on a policy of expropriation? And to me that almost seems like a bit of an oxymoron, because expropriation is a means to an end. It's not an end in itself. I think the objective of that, and the 1975 Act was no different, would be to facilitate the process, but the objective that you want to achieve would be infrastructure, land reform, nature conservation, whatever the case might be, that public interest, public purpose. So I think it's a bit of a challenge to, because it's become a proxy. It's a legal technical instrument which has become a proxy for wide debates, political debates, policy debates, when actually it's a very technical piece of legislation. So I think managing those expectations is a very, very real challenge.
Because when the public form their own opinions about this act, they listen to politicians. One of them arrived at Nampo this morning, Deputy President Paul Mashatile, who has said, Willem, explicitly that according to the ANC, this is the instrument that will enable government to accelerate land reform. And I imagine that in conversations with your members, this is often raised as a concern.
Yes, no, it's definitely a concern, but it's not limited to that. It's the political noise that goes around it, and that members start losing trust when people say things like that. So it's a challenge to see through all this dust that we're currently experiencing, because there's lots of different voices raising their opinion. The trust issue is why the people are so concerned about it, because if the wrong piece of legislation then gets used in the wrong way and people get bullied through that piece of legislation, then they lose trust and they lose business confidence, because we're farmers, we're business.
Of safeguards against abuse. The whole Act, its implementation is still subject to the Constitution, Section 25 of the Constitution, which was not amended in 2017 as many politicians wanted. Are there elements of this Act that you think introduce risk into this process, or are you satisfied that it's narrow enough and that the way in which it deals with agricultural land, if we can perhaps just pause there, is satisfactory? What does it say about land and agricultural land?
Yeah, so the difference between land and other assets, and what's interesting in Section 12, it refers specifically to land. So in the Constitution and the rest of the Act, it refers to other assets. But in Section 12, specifically 12.3, which deals with null compensation, there is specific reference to land. And I think for that reason is why farmers are so concerned. So Agri-SA has been involved in the process, giving our inputs. The reason why we against this Act is there's only 2 points why we against it. It's the definition of expropriation, and then the Section 12.3 that deals with null compensation, because we believe it's null compensation isn't fair and equitable like stated in the Constitution.
Willem, thank you. The party to which the Minister belongs is taking this Act to court on procedural and substantive grounds. Before I come to you, Jaco, Dean, I know that you are not here wearing a DA hat, but these things are often conflated, especially in a country like ours. The substantive concerns that the DA has with this Act focuses on the role of the courts in safeguarding the process, whether indeed expropriation can happen before a court is involved, or whether it can only happen after a court is involved. Are you also worried as Minister about this ambiguity in the Act, which your party believes renders it unconstitutional?
I think that there's no doubt that when you read Section 8 and 19, they are contradictory. I mean that's it's obvious. You can't have two procedures to deal with one principle. So, but the point is this, is that in my view as the Minister, that is resolvable. And what we are seeking to do is to find an appropriate way forward that satisfies issues that people may have with the Act. Because I want to state this up front, Valdemar. If the Act was to be, in my view, struck down in its entirety, and we go back to 1975, I don't know what's going to come after that. And in politics, sometimes you must be careful what you wish for, because often you can get it. And so, what comes after that is open to a new parliament that has very different dynamics, and that has parties that have very different internal dynamics. So my view as the Minister is, yes, I recognize that there is a contradiction in Section 8 and 19, but I think that it is resolvable, and my job as the Minister, A, is to try and provide resolutions to the concerns that parties have, and then B, to make sure that we have a regulatory framework that works parallel to the Act to ensure that any other issues around any other further definitions or processes is clearly spelt out, which we plan to do in a very consultative manner that includes agricultural experts, land reform experts, all types of experts, so that everyone is then very clear and happy on those regulations. But my bottom line as the Minister is, let's try and deal with contradictions, let's try and deal with those issues, and let's safeguard what, by and large, in my view, is an Act that provides those definitions and those clarities that are needed, that are above 1975 and above US federal law, and then move forward in a constructive way.
Jaco, the Minister of Public Works, believes that this Act can be operated, and it's not operational yet, let's emphasize that, in a way that is reconcilable with the Constitution and with safeguarding property rights. what are your main concerns about the wording of the Act as it stands now?
Yes, thank you, Waldemar. Thank you for the opportunity and for also everyone who are present here today. Now, I have all my trust in the Minister. That's not the challenge. We, as an organisation, also have full trust in the Minister doing exactly what he said right here now. But the problem is that we're not sitting on an island. When I read analysis of this Act coming from academics at universities in Johannesburg or Cape Town or wherever, I fear that people think that we may be here sitting on an island writing an Act, and trying to implement it in a kind of neutral political environment. My fear is that the decision to write this Act was very much politicized. It was made after the effort to change the Constitution failed, and that there was always
as a substitute almost for the
exactly
amendment, which didn't happen.
A substitute to trying to have the Constitution changed to have expropriation without compensation. So as just a different method to get to that point. And why do I say that? That's what politicians are saying. You refer to the Deputy President. He's here today, interestingly enough, at Nampo Park, but he's said it many, many times that is his mission. And I think that's not supposed to be in any way part of the reasons why we need an Expropriation Act. I think there's kinds of extreme opinions, that we need to cancel out. On the one hand, people saying that this Act will lead to large-scale expropriations of farmland. I don't see within the wording of this text of this Act that will happen. There will be many, many court cases and many troubles. That will not happen. But on the other hand, the people who are just saying this is a great Act, that will be well implemented. And I think there's a very, very short-term focus on that. I don't know who will be the Minister of Public Works in a few years' time. I do have trust in this Minister, but I don't know who will be there in the future. I don't know who will sit in courts. I don't know who will be the people who make a decision on expropriation. These people in municipalities who will be able to expropriate. I don't like the process prescribed in this Act. It will destroy certain people's businesses. We've seen over the last few years the challenges, when there's a legal process and it takes 3 or 4 years and you can't go on operating. And what will happen here is people, there's the possibility of someone's farm being expropriated, and then after that you will need to go to court. That may take 3 or 4 years, So I have problems with many issues in the Act, and specifically with the politics, the power element in the Act, and at the end the processes that will end up in court and that will lead to a lot of damage to South Africa's investment environment. We've heard this morning on radio one of our most well-known economists, Xavier Rood, saying that South Africa is already losing international investments due to this Act. Perceptions are everything in the kind of politics that we have in the world today.
I want to pick up in a moment on what you said about the low risk of wide-ranging land seizures of agricultural land, which I think is especially relevant for a room like this. But you mentioned something else, Theo, that I want to throw to you. Herman, welcome. It's lovely to have you join us. And this is which entities in government, which levels of government will be able to use this Act to expropriate. Of course, primarily the Minister of Public Works, it resides this mandate in that ministry, but it's not limited to national government.
No, you're correct, but that doesn't change through this Act. That has always been the case, and there's pre-existing legislation, and the who follows the what and follows the why. So in this legislation, the minister is empowered for the purposes of public works. Municipalities would be for things that fall within their jurisdiction, stormwater drains, whatever the case might be, municipal infrastructure. Likewise, there's 4 pieces of legislation that also, for land reform that allows that. The Minister of Mining under the Mineral and Petroleum Development Act. So this is pre-existing legislation, but the important thing is the who, what, where, and why already exists and is set out in different legislation. And where the whole public interest, public purpose debate comes in, because I know that's also a very topical issue, is it's not a blank check for a municipality to decide, I believe it's in the public interest, I want to expropriate this. It comes in as almost a second safeguard, a second level of safeguard. Because you have in law what's called ultra vires. So in other words, if you don't have powers in law to expropriate, then you cannot expropriate, that will be unlawful. Where the second level in the public interest, public purpose comes in is if you believe that Parliament has granted, a municipality, for instance, for a specific purpose, the powers to expropriate, and you don't believe that's genuinely a public purpose, you can challenge that legislation in the Constitution. So it's actually a second level comes in. And it's an interesting concept where this came from. Don't want to digress, but we always think we're very unique in South Africa. We're not. Our land reform and our land restitution process is largely based on what happened in Eastern Europe after the fall of the Berlin Wall. And there was a specific court case. They had a land restitution process, and their constitution, the German constitution, it's very closely mirrors our constitution. And expropriation took place for restitution to give back before, obviously, the world wars took place, to give back property to the original owners. And then one of those disgruntled owners took that to the European Court of Human Rights and said, but how can it ever be in the public purpose to take from one person and give to another person? And that's where the court then decided in the context, in their context, in their specific historical background, it is a public purpose, but I do think our drafters, and it's not by accident that interest and purpose is in our constitution, they preempted that debate to say, just in case we have those same discussions, we'll include something called the public interest and say it includes the nation's commitment to land, water-related reform.
And of course, any government action which is truly in the public interest would not be opposed, I think, by anyone in this room. I think the fear is that which is purported to be in the public interest, but which isn't, right? So the fear of abuse. Herman, I'm coming to you in a moment, but Dean, if I may, for a member of the public who might be the owner of land, let's focus on land and not on intellectual property or other forms of property, mining rights, which are also mentioned in the Act. But let's focus on land this morning. If you are the owner of a piece of land, under which circumstances could your land be expropriated under the terms of this Act for nil compensation? Because again, I don't think anybody's main concern is getting a big sum of money from the government for your land. So how narrow is that category of cases where you can be served with a notice or an intention to expropriate and go through the process of then losing against your will as an unwilling seller your land?
Let me answer it like this. I like to try and answer things by creating pictures. Everyone will agree that the state of our inner cities are disastrous. Buildings are overrun, hijacked. People have long left the country, forgotten about them, pay no rates. They are inhumane conditions and a danger to society. Now, the government has to do something about that building. Now, some would argue that in order to fix that problem, that the government should then pay market value for that building, even if the sum total of its outstanding rates, the legal costs to evict people illegally living there, and then to demolish it, are more than the market or more than the expropriation value. Why would anyone believe that it would be just and equitable to pay market value for that, despite all of the costs that are owed to the government? And even more when that person has long left, or they could still be here. It would make no difference. The state, in that public interest, should offer nil. It would be the court that would determine that they may say, considering all of those factors, that actually nil would be just and equitable, because the responsibility is borne on the state to right that problem. I mean, that sounds like a logical, just and equitable reason to offer nil on a case like that. What the court wouldn't agree to is to offer nil to a farm, considering the economic value of the farm, considering all of the other factors.
That it is in productive use, for example.
In productive use, that there may be a mortgage on the farm, that there may be farm dwellers on the farm. The court, I don't think, in terms of the Constitution, could come to that arrangement. Now, I've sat in debates where people have an absolute view, on the one hand, who say expropriation without compensation. Well, that is not a a lawful concept. There are some people who say, well, just offer them whatever they want. Let me give you another example. And let me use the transmission network because it's a really good idea. People have been colluding with officials in Eskom to work out where these transmission networks are going to be rolled out and started buying up all the land where those transmission networks were. They bought them for R1 million, and then they would go to say to Eskom, who is an expropriating authority, we want 20 million rand for it. For a piece of land that was bought a few years ago for R1 million. Is it just and equitable to offer them what they want? I don't think that that's in the interests of the broader community or the state. And so expropriation has to be seen. This is why I've tried to re-term it. And you know what, ladies and gentlemen, maybe the problem is the word expropriation, because as Jaco correctly said, it has been weaponized by politicians. So the word expropriation is so toxic and gets, our backup that we immediately have a very bad view of it. So let's maybe collectively come up with a new name. I don't know. But it's got to be seen, in my view, more as a tool for economic development and growth so that we can build new highways, build our highways, get our transmission networks going, that we can get this country moving from the stagnant place that it is in.
When the party with the biggest representation in Parliament, however, speaks about the Act, it doesn't refer to economic growth as an incentive, but land reform. So we'll get back to that. Herman, can you contemplate circumstances under which a government, and sometimes a well-meaning, frustrated government, might have to serve an owner with a notice to expropriate with nil compensation? Even Helen Zille in 2018, when she was Premier of the Western Cape, wrote a long article which was sent to me this week again on Daily Maverick about an instance in Mitchell's Plain where the owner of a large tract of land allowed that land, in fact encouraged illegal settlement of that land so that he could sell this land to the local government at an inflated price after doing illegal sand mining there for many, many years. And Zille then argued this was an ideal test case for expropriation without compensation, to quote her, or with nil compensation. Can you contemplate circumstances under which this Act could be used to do something which is indeed necessary?
Yes, that's not the problem with this Act. I can also imagine many other applications of this law. I think we're hearing a terrible level of complacency here when we're talking about nil compensation. This Act relates to nil compensation, not in public purpose, not for the building of highways or transmissions that the minister seems to be using as justifiable circumstances. No, Section 12.3 applies to public interest expropriation with nil compensation. That's not for building highways. That is public purpose. This is public interest.
Including land reform.
Including land reform. Now, the problem with the question of public interest is we often hear, and I think the minister himself has said this in the past, that this is a globally accepted concept of expropriation. Yes, for public purpose. Public interest is a very, very exceptional use of that awesome state power to deprive people of their property. Now, can I imagine circumstances under which a municipality or one of the at least 426 expropriating authorities in the country, I'm not sure if that's the right number. I stopped counting because I just lost focus after 426 expropriating authorities being identified. And I think the question of who is relevant, because I, for one, don't trust all 426 of them. But the problem is we can imagine a legal situation where that is necessary, but this Act isn't the solution to this problem. This Act is far wider. If the exceptional fringe cases are going to be used to justify it, we would expect narrow legislation. This isn't narrow legislation. In fact, Section 12.3 is an open-ended list of grounds for nil compensation, meaning any High Court, the Court of Appeals, and the Constitutional Court can expand that list. And if that is satisfying to, I think, this audience who relies on certainty in some respects because the industry they are involved in is fundamentally risk management, then I think it is just disingenuous to use that to assuage concerns. The application, the worry of this Act is not whether transmissions and highways and bridges and ports, inland or coastal, can be built. It is whether the risk premium of owning property in South Africa is unnecessarily heightened. If the Act is supposed to solve existing problems, it does so in an incredibly clumsy way. And the damage it wrought on the economy, if we're going to focus on getting it growing, then this is not it, I'm afraid.
Willem, in your conversations with members and with banks who hold a lot of debt in agricultural land, are there concerns that this lowers certainty in the agricultural sphere and ups risk in a way that is not conducive to growth, to put it mildly?
I think what's important is to look back a bit on what the farmers has had to deal with over the last 30 years and the risk that they had to work through and that they had to take to grow the industry. And through other pieces of legislation, there's been various times where there's been offers of less than market value to farmers. It has been necessary for Agri-SA in the past to get involved in some of these legal cases. We always see a legal case as the backstop. If there can be an amicable solution before then, that is what we prefer to do. But sometimes it's necessary then to defend that right. And we had to go to court before, and we had positive rulings and outcomes from those cases where we had to get involved with. So this is not something new in this new piece of legislation. It's something that farmers has been dealing with for quite some time.
But does this act change the level of risk? Does it push the risk up?
Definitely, because it's a new scenario, it's a new flag. So there is a change, but it isn't as new as some people would like to make it out to be.
I would argue that actually the risk of the 1975 Act was far more heightened than this Act, because there was no procedural determination, and it was up to any expropriating authority without a trumping Act.
Right, but that Act didn't include express provision for nil compensation, right?
Well, the court, and let's be clear, Valdemar, nil is a form of compensation. Sorry, I'm talking. Where?
Nonsense, though.
Dean?
At least I was on time. So,
yes, that affects the argument. No.
Valdemar, here's the point: is that nil can be a form of compensation, as I've outlined. That is absolutely true. And if anyone wants to live in this absolutist world, where the state must just pay, whatever you want, you're actually arguing for a form of extortion, because that's exactly what that's going to lead to. You've got to have parameters on how these things work. And as I've argued in that case, now I can take you through, and we've mapped this out in terms of the farm example, and to try and help the fearmongers understand that there is a set way of how this is looked at. I'm utterly convinced that nil is not an acceptable or applicable outcome on a farm. No court will come to that determination, because it does not align with the Constitution. It does not even align with what the public interest is as well. So, I think we must actually be fair in how we deal with these issues.
Right, but Theo, let's just pause on nil compensation for farmland again, because I think that's the most salient point today. If you are using your farm productively, and I don't know whether definitions of that might differ, are you exposed to any risk here of your land being expropriated with nil compensation?
So we're going to try and answer that in two segments. So the technical interpretation, which we might differ on, but my technical interpretation, and I think practically speaking from an agriculture point of view. So from a technical point of view, I don't interpret this legislation as prescribing a set of circumstances where you will not get compensation. There's only one form of compensation that is just and equitable. So what I understand Section 12.3 to say is that having regard to all relevant circumstances, including some which the legislation tries to, be indicative to the court to say, consider these as well. When you start at market value, and this is the established practice for expropriation, start at market value, apply all relevant circumstances, it can go up or down. Now what it says is it is theoretically possible, if the right circumstances apply, that when it goes down, it ends at nil. Now again, that would have to be incredibly, I think, exceptional circumstances for that to take place. Now, So I think, first of all, that's the first thing. I don't think there's a list of no compensation because the Constitution was not amended. That would have been a different
right, but there not being a list is a risk, right? Because as Armand says, there's an open list. It's not a what do the lawyers say, numerus clausus, right? It can be read more broadly.
There's an open list of circumstances that must be taken into consideration.
Right.
So what that actually includes is the same thing if you have relocation costs, if you have a mortgage bond, if you have a consequential loss as a result of that. It's open-ended, which is positive, which means that can also be taken into consideration to arrive at how much compensation. But just on a practical level, and you mentioned earlier about sentiment, and it's so important, the major financial institutions have looked at this. They've obtained legal advice. They have not adapted their credit criteria because, based on this. And I think we have to be very, very careful when we talk about sentiment that doesn't become a self-fulfilling prophecy. And if you look at agriculture, we had a discussion 2 days ago, here at Nation Conversation about navigating the political landscape. And what came out very clearly is to say, yes, you can, around the fire, talk about the what-ifs and the politics, etc. But what is facing you from an agriculture point of view right now? What are the risks? The risk would be bad road, high cost of capital, for instance. So I would say, and the way I know, obviously, the agricultural sector, is that the chance is that if you take your eye off the ball, I don't think the state's going to take your land. Your neighbor might just buy your land if you take your eye off the ball, and that's what's. So I think that's the real risk.
Jaco, if people tell you that you're fear-mongering, I mean, that was not directed at you, but what do you say?
No. I will seriously differ with you on this point. I mean, you represent big banks and big agriculture. I represent the common people walking here at Nampo Park. Those are the Solidarity and AfriForum members who are really worried and concerned about that, and they will tell you that it's not true that banks haven't changed their lending rates. I've been talking to banks about that, with farmers about that recently over the last few weeks, numerously. We must be very honest that, again, South Africa is in a phase where people are really worried and concerned about the future. We're in a time in South Africa where things can really go one way or another. And people, I've spoken this morning here at Nampo Park with a farmer who need to invest in his farm. He just have some capital available. He need to make decisions on reinvesting on his farm in terms of, and it's specific farm where you will only have real make some profits out of that investment within, say, 5 to 7 years from now. Very difficult decision to make, So I think we must be very honest with ourselves, that the whole issue of nil compensation was a politically driven decision to include that in the Act. And the fact that it is open-ended, and if we put all our trusts in courts and certain judges, we've seen what happened with water rights in the late 1990s when that was nationalized, the same with mineral rights in 2002, and the effects that had on our economy and the corruption that caused. I mean, there's still today enormous corruption with mining rights. We know of the challenges with mining licenses, applications to mining licenses, So I don't put all my trust and hope in courts and in whoever will be in the minister's office in certain places. I would have loved to have a better Expropriation Act. I do agree we need a better Expropriation Act than the one of 1975. That I agree with the minister on fully, but we needed something better than this.
So this act will, Herman, go in all likelihood to the Constitutional Court. The DA is litigating, and a number of other institutions are opposing the Act as it stands at the moment. How likely is this Act, according to the Institute for Race Relations' reading of it, to pass constitutional muster, or do you believe the Constitutional Court is likely to strike it down or amend it?
I think it's unnecessary to be in that position of risk in the first place. I think if Minister McPherson is going to tell us it was either the 1975 Act or this Act, it's just not the case. There were better alternatives on the table that would have been less destructive, less legally uncertain. So if we are going to try and anticipate what the Constitutional Court might decide, I think you've got evidence that you're dealing with a bad law. Because a well-written law...
What is that evidence?
With the fact that you're asking the question. The fact that we can have uncertainty as to whether the court will strike down or uphold this law based on the open-endedness of Section 12.3, the conflicts in terms of the role of the courts between Section 8 and Section 19. I mean, we hear that the courts are these magical panaceic protector of property rights and interest. The Act can't even agree with itself on at what stage the courts get involved. According to Section 8 and Section 19, you've got differing timelines of when the court can actually hear. And the minister says that the courts will decide the compensation. No, they will approve or deny the compensation. That's different from deciding. The expropriating authorities will be able to make the offer they think fair. And then on personal dime, people affected will be able to ask the court to thumbs up or thumbs down.
Just drill down into that for a minute more, if you will. This is also the basis of the DA's substantive challenge of the Act, is this confusion about when the courts are involved. Expand on that.
So according to Section 25.4 of the Constitution, expropriation of without compensation or with just and equitable compensation can only occur after a court order allows it. This Act, in its original 2020 wording, removed that completely. And then in 2023-4, a contrasting article was inserted into the Act to say that within 180 days of the expropriation offer being finally made, the court can either condone or not condone that expropriation offer. But the problem is that the original wording, that the court can step in either immediately at the stage of expropriation or within 180 days, that uncertainty still remains. And if we're going to talk about economic growth, surely we have to talk about the rule of law. And the rule of law has a fundamental component of legal certainty. If something can't be legally predictable, if ordinary citizens can't understand it with a reasonable reading of the law, then you don't have legal certainty and it can't be in accordance with the rule of law. So the fact that we have Section 12.3 open-ended, the fact that we have contrasts in where the courts can play a role between Section 8 and 19, these are legal uncertainties. And a few weeks ago, the minister in the Midlands at a meeting said that the far left want to expropriate things without compensation, and the far right, was his words, wanted market-related compensation. Well, in that case, it seems that we have an awful lot of people on the far right. What portion of your property does the state have an entitlement to?
See, the problem is, Valdemar, you can't deliberately misquote what I said. I was at the meeting, he wasn't. What I said is that we cannot just allow and just say, and I use the example of the transmissions lines and people who have been buying up land in collusion with Eskom officials, just to say, well, pay me what I demand. That's unfeasible and untenable.
But I think, permit me to interrupt you, that there's consensus on that. I don't think anybody would support somebody who maliciously withholds the sale of land and thereby inhibits the building of transmission lines.
And the Act says nothing about that.
So, because your party itself is opposing the Act on some of these same grounds that Herman is citing. But you're in a difficult position as member of the cabinet, and I'm wondering whether any of these concerns raised by people across the political spectrum, whether any of these concerns are landing in cabinet, whether cabinet thinks that any of these concerns are valid, right? And whether you believe that any of these concerns are valid.
Well, I can't speak on behalf of cabinet. I can only speak as the minister. And my view is that I have to try and find a way to deal with some of the legal challenges that have been made. I again reiterate the point that I think it would be a bad case if the Act is thrown out altogether.
Because of what might come.
And then you're going to roll the dice in Parliament. And Valdemar, and let me say, as a politician, the question is always compared to what? So what comes next? I don't know, and none of us know. So let's try and fix what needs to be done, and to try and avoid the worst case scenario. And I think that some of the organizations that have gone to court or joined as amicus, or the first applicants, I think that we can deal with some of those issues, and again through the regulations. But I think that if we want to talk about stability, if we want to talk about certainty, I think going back to the starting blocks, that's going to drive uncertainty to any level that may or may not exist at the moment.
Willem, sentiment in the agricultural sector has been buffeted by many winds over the last 30 years, quite frankly before that as well. Is sentiment improving? Is it worsening? I mean, if you do a dipstick exercise, Yaku mentioned members of their organization walking around Nampu Park. You also speak to many of the same people. If you were to do a dipstick exercise to measure temperature, what are members telling you in confidence? Surely there's the full spread of people who are less worried or more worried. What are you hearing?
No, members are concerned, but they're concerned about a variety of things.
Yes, but let's focus on this act
not
now.
limited to. But so it's important to understand the farmer's heart. He looks at risk. He wants to manage that risk, and it's part of that risk. So there is a big concern regarding expropriation, and it's the uncertainty that comes with it. So as soon as there's uncertainty, people start holding back investment, and we need to grow. So to get to that necessary growth, we need the confidence.
So how do we get there? How does AgriSA believe that this act can be, or that the weaknesses in it can be addressed to give farmers the certainty they need to make informed investment decisions?
Yeah, so working towards policy certainty is there, and that's why we've been involved from the start. And that is many from 2008, giving our inputs.
Right, but you didn't get what you wanted.
We didn't, but we didn't get exactly what we wanted. But there were lots of other stuff that we did have massive successes on. So the end result isn't because of those two specific points I mentioned. Is why we against this act. But if we can work on those 2 points and get the opportunity to work to get those 2 points right, we'll definitely build on the confidence that's necessary.
Theo, so contemplate some scenarios for us, please. This act in the hands of a minister who says under his watch there will be no expropriation without compensation or with no compensation that is unreasonable, versus a next minister, if one can contemplate the scenario where the government of national unity doesn't last forever, which everybody's contemplating.
Nothing lasts forever.
Yes, nothing lasts forever. Talk to us about this act in a pair of hands, in the hands of somebody who's not malicious, and this act in a pair of hands of somebody who wants to nail farmers.
Yeah, so I think definitely, I mean, we've stated now that there's a big political element in terms of the discussions that's taken place. But the beautiful thing about the rule of law, and which has been mentioned, I think, by everyone today, is the rule of law dictates that legislation has to be clear and it gets interpreted by the courts. So that is a safeguard that will prevent this being, it's not at the whims of the expropriating authority. There are those checks and balances in place.
But there is uncertainty about whether a court can give its blessing before a piece of land is indeed expropriated, right? There is uncertainty about that.
So the procedural aspects, was touched on in terms of when the court come in, but it's very, very clear. And I mean, and that goes back to Section 25 of the Constitution. Compensation has to be either agreed upon or decided or approved by a court. That is the upper threshold that cannot be bypassed. So there were the 2008 version of this bill, we were also quite closely involved. That did intend to limit the access to courts, and it was completely redrafted as a result. So that's why this 2013, that's where this bill has got its origins in. So the beautiful thing about the rule of law is the courts are the only body that can finally interpret the laws, and irrespective of intentions, malicious or benevolent intentions behind it, finally, ultimately, the courts will have the say on compensation. The courts will also have the say in terms of whether an expropriation follow the right procedure, will also have the say in terms of whether it is in public interest or public purpose or not. And unfortunately, and I do understand, litigating at the state, and I think in the introductory video we mentioned that it's a challenge. It places the onus on a party who has now been approached to do it, and I don't want to undermine the challenge that will cause. But if your rates and taxes bill is wrong, if anything like this is wrong, it's the same process, unfortunately. That's the way public law works. So it's a challenge. I know some attempts were also brought into that, to try to assist the landowner or a bondholder to assist the court, placing obligation on the state, if you can't reach agreement, to put it down on the value roll to to be taken up to court.
Thank you, Theo. I'm going to come to you in a moment. Herman, surely this the fact that this any implementation of this act is still subject to Section 25 of the Constitution, which gives substantive guarantees against arbitrary deprivation of your land. Surely this constitutional guarantee counts for something.
Yes, it didn't count for much in the water rights, nor did it count for much in mineral rights. The Constitutional Court has been very creative. It created this idea of public custodianship, which differs from state ownership. It says we take something into custodianship. We're not actually taking it into ownership, so we're not violating Section 25 of the Constitution. So I see no reason why water rights could be thus undermined, approved by the Constitutional Court. Mineral rights could be thus undermined, approved by the Constitutional Court. Land rights have no special pleading here. And I think what the problem also comes in the sense that, yes, the courts might be some pressure valve, but I don't know if people are actually familiar with the cost of litigation. And if you have lost, as an emerging or medium-sized farmer, your greatest asset, you've lost your income. You've lost all assets connected to that property. You've just lost, essentially, the bulk of your economic ability. Where on God's good earth do you think the money will come from for the litigation? I think that it is platitudinous, and it is rather cynical to think that that the court's oversight role is cost-free to the people affected by this.
Thank you. We only have a few minutes left, and there will be some time for questions. And Dean, I'll finish with you. Jaco, in 2018, the American president first became aware of efforts to change the law around expropriation. And Tucker Carlson did a piece which prompted Donald Trump to say on Twitter, 2018, 7 years ago, South African government is now seizing land from white farmers. This has never been true since '94, has it?
No, it's never been
It's also
true.
not true now.
No, it's not true. And I mean, I liaise with the American government on nearly a daily basis at the moment. I've told them there's no genocide and there's no government seizures. You know, there's land invasions, which is a big problem. And I'm really concerned that this act may lead to more land invasions. You know, it's really difficult for a small farmer when people are just invading his land to get people off his land, to go to court, to find the money somewhere. Agricultural organizations like Agri-SA, SAI and others need to assist farmers on that. That can become very costly in future, you know. But that's not happening, and I'm telling the American government the same. What I am asking Donald Trump, to next week when President Ramaphosa will visit the White House, put pressure on President Ramaphosa on this whole issue of expropriation and the whole issue of null compensation. You know, we don't need an expropriation act for land reform in South Africa. Valdemar. The minister has been clear on the number of farms that are unutilized in South Africa. I think something like 800 farms that are just laying bare 2.5 million hectares of agricultural land. We don't need expropriation to have land reform in South Africa. Land reform is very important, you know, but the biggest challenge in South Africa, like in agriculture in Europe and America and other places, is that people don't want to farm anymore. The average age of a farmer is in most countries more than 60 years. You talk about Eastern Germany. When you visit those Eastern German states, there's just 70 years plus people on those farms. Farms are not utilized anymore. That's the challenge. Yes, we must have land reform, but we don't need expropriation for land reform. And we need the president to say that. We need the vice president to say that. And we need all ministers to say the same.
To the only minister on the panel, Dean, which of the concerns that you've heard today and in your conversations with members of the public walking around here, which of these do you think are worthy of being raised in the next cabinet meeting? Is to say, guys, there are many people who understand the act correctly or who understand it incorrectly, but they are worried. Which of these concerns do you think should be taken to Cabinet and discussed there? Because you are in a unique position as a member of Cabinet to articulate on behalf of constituents and voters and members of the public to articulate their concerns in Cabinet.
Well, actually, I think it's a good thing that you have maybe ever the biggest representation of government coming to Nampo. I think that's positive. President, Deputy President, Minister of Agriculture, and myself. And I think that shows the importance of agriculture. And I've had a discussion this morning with with the Deputy President in a briefing and reiterated that point, that agriculture is a sunrise industry for South Africa. It should be. I'm sure the Minister of Agriculture will make that point later. You know, Valdemar, I don't conduct my business via soundbites and tweets and, whatever. I actually engage with organizations, and both of the organizations here will know I've engaged them. I've engaged other organizations as well, because I want to find solutions. I don't want to shout how bad and cursed the sea is that we sail on. We've got to find solutions. And so I think that one of the important things that I think we can resolve on is the contradiction or the problem between 8 and 9.
The role of the courts.
Yeah, I think, and I think that we can solve that one, to be perfectly honest.
By amending the Act or by doing...
Well, we are currently looking at what are the options, because, my role as the minister is to provide answers and to provide solutions. That's what I want to do. I want to be constructive. I love agriculture. I'm sort of a closet farmer, if I might call myself that, if there is such a thing. Although I don't look like one, but I do try my best. Annette Stein, my great friend, has been bringing me to Nampo for 10 years. So I value the role and the importance of agriculture, and feeds our nation, employs 1 million people. So I am working with the government to find those solutions. It's what my office is seized with. And I think that if we get it right, we will be able to satisfy the vast, vast majority of people. And you know what's really been interesting being here this morning? We're speaking to economists how not just sentiment, because sentiment is a feeling. I want to measure sentiment by investment. Investment in agriculture is up. Some guy was telling me they sold a 13 million rand tractor yesterday. That is not the direction of an industry where people are fleeing, where people are terrified of what's to come. In any society, people will always have concerns about laws. I have concerns about many laws, the speeding laws. I think that maybe we should bring down the speed limit, but it doesn't stop me from driving. And that's the point, is that I think we've got to move forward. We can do so, and I'm happy to take anyone's opinions and inputs into the way forward. And when we draft those regulations with the inputs of experts, I think that will also provide further clarity as well.
Dean, to all members of the panel, Herman, Willem, Theo, Jaco, thank you very much for joining us this morning. Our time has run out, but can we have a round of applause for the panel, please? I think that we have 15 minutes for questions. Is there anybody who is going to shake their head or nod? Yes, 15 minutes for questions? I think so, yes. Okay, let's take 3 at a time. I'll try and identify hands in a way that is as fair and non-arbitrary as possible. One over there, let's take 2 more hands. Any other questions in this round? Nobody, okay, please, thank you. Please introduce yourself if you can.
Hi, ladies and gentlemen. My name is Mafezi Zikali, and I am from Future Farmers in Howick. And one of my questions that I have is that Stats SA reported that the agricultural sector employed about 900,000 people directly and 200,000 people via agri-processing or that value chain. So what we'd like to know as an organization that promotes young people to actually join the sector and become employees and employers, how does the bill, or what is government and the other organizations doing to protect job security in that area and also to protect agricultural production? Thank you.
Thank you very much. May I suggest, Willem, will you take this one?
Also, by the way, I met her in Howick, and they're doing a great job.
So I have to take the opportunity. We're always looking at membership categories, and we haven't had the closet farmer member category yet. So we'll definitely have to look into that.
I'll be the honorary president then of the closet farmers.
Is that a higher membership fee or a reduced membership fee?
So to answer the question, the job creation is a big concern, and it comes again back to the confidence. So I can really recommend everybody here to read Wandile and Prof. Kirsten's latest book, where there's lots of detail and referring to land lying fallow, the land in the land holdings account, but also land that's been transferred to various parties, and that land is lying fallow. And the possibility of job creation on that properties that government is sitting on. So if there's investment confidence and we can access capital to get those farms going, then there's lots of opportunity in job creation there.
If only
so go and read the book.
If only we had somebody from government here. Oh, well.
Yeah, let me just say, you know, one of our missions or obsessions is to use public assets for public good. It baffles me that the state holds on to all of these public buildings, 5 million hectares of land, and so we are doing some really amazing stuff in pilot projects, more on the building side. But we also do want to look at how we can use land that the state owns or under public works for those kinds of partnerships. We're also looking at some fascinating work around debt swaps to lower South Africa's debt payments using land that we own. It's called debt for nature swaps. It's a big thing in Europe at the moment. So, but you know, again, I'm one minister. You know, we have thousands of officials, but we need partners, and that's, you know, I think what government hasn't been maybe as agile as they could have been. But I do detect and sense a change in that. So, you know, I think that you will see a greater desire for partnerships, particularly with us. So I know we did meet each other in Howick a couple of weeks ago. So, you know, wherever we can help, we are certainly prepared to do so.
Thank you very much, Jaco.
I think, a very important question, because we're also internationally in a phase of mechanization in agriculture. So you see less and less jobs in many countries in the agricultural sector. So I think what we need, and we're busy in projects in many communities in South Africa also, is to make sure, I think there's a few things missing in South Africa. Property rights, give people, when people farm on a property, give them the right to own that, because then they can have access to capital. We have a skills problem in South Africa. We have a perception that every South African need to go to a university and study in the humanities or languages or something like that. We must give people training in agriculture and technical skills, you know. That is so important. I've been to the Eastern Cape, to some of those communities, and people need the capital and the skills to do that. Partnerships are extremely important. We work on a few projects where I think there's a very, very, and you see that also at NAMPO, a willingness from agriculture in South Africa, from commercial farmers, but also from agri-businesses to become involved in this. But at the end of the day, we need to focus on the right things, and that is property ownership, training, access to capital, partnerships, you know, and not so much on all the politics. We're always busy with the politics and people being angry at each other. You know, we just need to get people in communities busy with solving these problems.
Theo, anything to add as I ask for more questions? I see a few more hands.
I just want to add on in terms of my organization being a bit different from government or the others, is we try to understand the law. And we wrote an alternative expropriation bill in 2020 that would have neutralized many of these issues. So from our side, I would encourage people to read that bill, that concept legislation, and perhaps in engagements with decision makers, promote some parts of that bill. And I think young people are perhaps a particularly potent voice to do that.
Thank you, Aaron. Let's take a few more questions right at the back. Just any more hands, and the second row from the back. Thank you, sir. Thank you.
Thank you to everyone. Thank you for the opportunity. My question is directed towards land use, right? So some people own farms, title deed and all, but are owned in personal capacity, not under a trust or a different entity. So with these farmlands that are standing barren, people come and want to herd their cattle on their neighbors' farms because they see the neighbors are not utilizing them effectively, and people don't want us to use their land and produce something for our country. They just want the land to sit and stay while they are arguing amongst themselves about the legalities of use, right? My question here, is there anything set in? Is there anything set in place? Is there any way where we can access these farming spaces, be it we compensate the owners or not, but to not have standing land, to not have barren land that people just walk up and down on? I don't know if my question makes any sense.
Yes, thank you. And just your name, sir.
My name is Fano Mchinyari. I'm from Secunda and Mpumalanga.
Thank you, Fano. Let's take one more question before we get to the answers for yours. Third row from the back. Thank you.
Hi there, I'm Stefan. I'm from a bank, not in an official capacity here. I just noticed there's a lot of vast difference in opinions there, and it doesn't seem to me like there's an agreement on the impact of this act. What are the next steps to get closer between the parties? What's going to happen? Because it is causing a lot of confusion. It is causing some impatience out there. People have got different expectations of this act. What are the next steps? I mean, we can't just let this play on and play on and play on. I would like to know if there's a plan in motion. Thank you.
Thank you, Stefan. To Fano's question first, I guess Theo or Willem, are there mechanisms to solve this frustration about land which is not reaching its full potential, perhaps?
Yes, I think that's one of the challenges that we sit with in South Africa, is that there's not enough known about land and the land use. So there is a big drive now with the land register to get more information about who owns what and what's happening on that land. It's meeting some resistance because there's information that the state wants to gather. But it is in trying to solve this issue that we don't know enough. How much land does the state actually own, and how much is lying fallow, how much is not in use? So I think that it'll be necessary to work towards getting more information on land use, to debunk some of the myths, but also to empower some people that do have the skills and do have the passion that wants to farm. We want to see more people getting involved.
But is there a desire in government to address the frustrations of farmers, like Fano articulated now, to say, we hear you, and ideally we would want you to be able to be productive?
Unfortunately, the track record up to now doesn't state or doesn't show that there is this desire. And I think that's why there's also a hand coming out from government side to say we need to build on these partnerships to address some of these issues. Because land lying fallow is bad in various reasons. It's not just the production side of things, but it's the devaluation of the asset, the effect that's going to have on neighbors as well. So it's really detrimental more than just not producing.
Thank you, Willem. Herman, and then Theo.
I think that's a very, very good question. My advice would be to make property rights as strong as possible, because then banks can rely on those assets to extend easier finance so that younger emerging farmers can have the credit to actually go to a neighboring farmer and say, I've got the credit capacity to come to you, to pay you, can we come to a negotiation settlement? So I think if we want to actually make sure that land is optimally used, we should acknowledge its value so that you can use your land as security for such financing, for such deals, and also the banks can have the security of their asset books to know that they have credit available. So to make that circle complete, it gets back to strong property rights, strong title deeds, as Yaku said.
I guess some farmers just don't own any land, though. But
exactly,
yes.
And that's why the finance from the bank side should be as stable and safe as possible, getting back to their asset value.
Right. Yeah.
Just one thing to add, I think it complements what's already been said, but the one area of land reform that is not often talked about, and not often talked about enough, is communal land reform and tenure reform. About a third of our population as a country live in a communal areas, the former homeland areas, and I think if anyone has sort of reason to complain, it's most likely them, because the legality of their tenure and the security of tenure really does undermine the productive use.
Very weak property rights.
Very weak property rights. No, absolutely. And it's the same thing with municipal commonages. So there's and that's resource neutral. It doesn't cost anything. That's legal changes that need to take place that can unleash the potential of some of that property.
All right. Next steps to Stefan's question. So I know, Herman, that you guys have an alternative bill, but that's not the one that is becoming law. So what happens next? We know that there are court challenges that have been lodged. Is the Constitutional Court or a High Court Dean, the next step for this act, because it's going to go to court?
So let me just say, I don't actually have a problem with differing voices. I think the more differing, the better, because that's actually how you come to completeness in your thoughts and arguments. So I don't have a problem with that. And I also think that we must be careful that we don't kid ourselves into believing that we're going to live in this utopian society where everyone agrees with each other. So disagreement should not be seen as negative or problematic. I think that what the problem is how the issue that I have, that NIL and EWC have been conflated to be the same thing and have been weaponized politically and outside of politics as well. And I think that has created more fear than people actually realize and understand. There's a reason why President Trump keeps talking about people's farms being taken away, because people have somehow got that information to him, and I question why. Why would they do that? Why would they go and say that farms are being taken away when it is just simply not true? So the disagreement is fine, but so long as it is not, so long as it is truthful. The way forward that I see and that we are working is we are trying to find a solution for those that are involved in the court case, to see whether there is a way forward that everyone can agree on.
These parties, it includes
everyone. It inclues all the
Agri-SA in that court case?
Whoever's involved and whoever is amicus and the respondents. We want to try and find a way forward, because I think for the stability of the country, as soon as we can settle that act, and as soon as we are able to develop the regulations alongside, I think the better off we will be. I obviously then can't stop someone who wants to then go and take that to court, but we live in a free democratic society. So that's how we are trying to move forward in a constructive way. We take many opinions on board, we take many inputs on board, and that's how we're approaching it.
One last input, I'm afraid, is all we have. Theo, do you want to conclude from AgBiz's point of view? What is the next step from commercial agriculture's point of view to address concerns among your members and take us forward?
So I think it's just about getting the best possible information. Each person has to collect all the information available, make their own judgments, look at the credibility of where the information is coming from. Because the challenge is uncertainty exists in business amongst many things. We've got uncertainty about trade, what's going to happen with our trade, the whole geopolitical environment. But the message we got very clearly Tuesday is focus on those aspects that you can control, that you can influence, ensure that you're competitive as you can, and try to, as far as possible, cut through the noise. And I understand from a financial institution, you need to make certain decisions, you need to price in risk, etc. And there, I would just say, just get the best advice that you possibly can. And again, these things can be mitigated. I do believe, just like our trade relations, a geopolitical situation, there's uncertainty, but unfortunately, business, it's a survival of not the fittest, of the most adaptable. And I think that is definitely going to be the case in agribusiness as well.
So it does seem as if there is a process in government to attempt to address some of the concerns about the Act, but if those concerns raised here today are not satisfactorily addressed, it's going to court. So those seem to be the next steps. I think there are still lingering questions.
And to the ballot box.
And to the ballot box. But to the panel, thank you very much for giving your time and energy today, and thank you very much for joining us.